Welcome back to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan, along with Joe Bankman.
Greg, or before the break, we were talking about a case, Brackeen versus Zinke, and one of the aspects of the case is the federal government's authority to regulate tribes. And as it turns out, there are not one but two commerce clauses in the U.S. Constitution. I'm wondering if you could explain a little bit about the differences and talk a little bit about the so-called Indian Commerce Clause.
So for a long time, the Indian Commerce Clause has been read by the U.S. Supreme Court to give the federal government what is called plenary power over this body of law called Indian Affairs. And plenary power basically means the federal government can, by and large, do what it wants. And that was in part responsible for some of the historical injustices that Pam was referring to earlier. But it has also been the foundation for statutes like ICWA and these other more recent laws that have sought to protect tribal interests and sovereignty, particularly against private individuals and against states. So, you know, it's a double-edged sword for tribes. In class, I call the federal government the tribe's frenemy because of this sort of dual nature and role that the federal government has played throughout history.
Yeah, I mean, the federal government, it turns out, sometimes to treat Indian tribes as foreign nations almost with treaties, and then it disregards the treaties even more than like pulling out of NAFTA or pulling out of the Trans-Pacific Partnership. We had a lot of practice with that, with some of the treaties with Indian tribes.
So, yeah, that's absolutely right. So that's why this challenge, part of the Brackeen case, is challenging whether Congress even has the power to enact this statute. And the amicus brief that I co-wrote really focused on pointing to the broad basis within the text of the U.S. Constitution for upholding this authority. So I argue that it's not just about the Indian Commerce Clause, but about all these other provisions, the Treaty Clause that Pam just referenced, the Supremacy Clause, aspects of what is called the Property and Territory Clause. And if you look back at the group of people that we now call the framers, they really had a holistic understanding, and they really sought to prevent the intervention of states in this area, similarly in some ways to the way that they sought to prevent states from interfering in foreign relations. They had the same fears. I think it's important to remember how much power Native nations had at the time that the Constitution was drafted. They had tremendous amounts of military power. They defeated the United States in the very first battle that they have against the United States in 1791.
Yeah, and one of the other things that you're such an expert on the time of the framing is Reconstruction and the 14th Amendment and the ability to enforce equality for Indians. That's where, for example, the parts of the Voting Rights Act that provide special protection to Native American and Alaska Native voters come from. They don't come from the framing so much as the idea that you have to protect tribal members from the kind of prejudice they often face in the states.
Yes. I mean, I think it's important to emphasize the ways that Reconstruction both altered but also maintained that earlier legal framework. There was some discussion around the drafting of the 14th Amendment. And actually, you referenced the Indians not taxed language.
Right.
They put that back into the 14th Amendment. And there's a case soon after the adoption of the 14th Amendment that says, no, Indians are still not birthright citizens, even after the adoption of this amendment that seeks to overturn Dred Scott.
Yeah, it wasn't until I started doing some work on Indian voting rights that I started reading these cases, like the case, I guess it's from Nebraska, where the guy goes to vote in 1870. They say, no, you can't vote. You're not a citizen, even though, yes, you live in Omaha, just like everybody else. Jared, I wanted to get back to you to talk about some of the work you've been doing in addition to the amicus brief project, gathering all the cases for NARF. You've also been doing more direct services style pro bono work. Could you tell us a little bit about that?
Yeah, we've done 2 trips now up to the Yurok Reservation, which is in Northern California. It's just a few miles south of the Oregon-California border. It's a really beautiful area of the country, but it's also a part of the country that has a high level of need of all types, including legal need. And so what we've done is NALSA the Native American Law Students Association, our Stanford chapter, has organized 2 pro bono trips up to the Yurok Reservation. Last year we went up and we did a criminal record expungement clinic, which is so important for making sure that members of Indian nations can thrive and interact in the economy, get jobs, rent apartments, all that. And this year we did a wills writing clinic to make sure that Native peoples can retain the property that they hold, not just real property, which we often think of when we're thinking of wills, but also personal effects and cultural patrimony, which is important to make sure it gets passed down to your descendants as well.
This is Stanford Legal, and today we're talking with Jared Crum and Greg Ablavsky about Native American rights. And I just wanted to follow up a moment, which is you said you went up to the reservation, and is there generally are legal services generally available on the reservation, or is it far away and hard to find lawyers?
It's both. It's far away and hard to find lawyers, but they also have legal services already there. So it is far away. It's remote to major metropolitan centers, so it can be hard for people to get legal services or to get affordable legal services. That said, they already actually have a terrific Department of Justice in the Yurok Nation. And the Chief Judge, Abby Abinanti, is terrific. She's award-winning. And the justice system that they run there is very connected to the people, and it's excellent at settling disputes in a culturally sensitive and culturally appropriate and culturally competent way. And that's exactly what we like to see. We like to see tribes exercising sovereignty. And one of the things you do when you exercise sovereignty is you have a court system like any other sovereign, and you use it, and theirs happens to be really good. So we kind of see ourselves as supporting them.
Yeah, I think the point you're making is a really important one, which is with respect to adjudicating issues that come up within the context of the reservation, you can have a tribe that does a great job of that with its own justice system. There are a number of tribal Supreme Courts around the country that are very well respected. And the expungement stuff you were doing was outside of that system because they had to deal with the California state legal system as well, right?
Yeah, that's, I think, a theme that's kind of underlay our whole discussion here. Tribes and states are always interacting with each other, and they often come into conflict because they're both sovereigns within our constitutional system. They're both subnational sovereigns, and so there's naturally they naturally can sometimes clash on these policy issues. This was an opportunity for us to use California state law to help tribal members, which was really good.
Yeah.
Jared, I'm a little bit entranced, as I think a lot of our viewers and listeners might be, about the notion of this separate tribal justice system. Can you say what struck you as the best thing about it or the most surprising thing about it?
I like the size of it. It's very connected to Yurok. The tribal justice, main justice, quote unquote, at the Yurok Reservation is right near everything else. And you can just walk in the front door and you obviously have to go through a process to get your case adjudicated, but you can. And the thing that really impressed upon me just how connected the justice system is to the people at Yurok is the fact that in their main courtroom they have a conference table and it's separable into 4 or 6 different tables, but when you put them all together, the pattern that it makes on the table is the Klamath River, which is everything to the Yurok people. So I think that kind of shows the ethos that goes into their tribal justice system.
Thank you. Thank you. You know, we always run out of time on great conversations. Greg, you have a pro bono project with the tribe that involves, of all things, coming up with the tax code.
Yeah, so we've had a group of students who have been doing some work, doing legal research and assistance for the tribe, trying to help them. I think it's important to stress just how central resources are. Jared, I think, alluded to this. And the jurisdictional complexities of Indian law make taxation a real challenge and have forestalled the economic development of many Native communities. And so we think that this is a really important work that we're helping the tribe do.
Well, maybe on another Stanford Legal, we can hear more from Jared about tribal courts and more from Greg about tax policy, which some of the listeners know is one of my fields. I want to thank you both for being here. We looked at a case which has to be riveting for everyone, pitting what we normally might unreflexively think of the best interest of the child versus the notion of getting the tribe and tradition in at the table to decide custody issues, to how the federal government regulates tribes and how they should regulate tribes. Thank you.
So thank you for joining us on Stanford Legal here on Sirius XM Insight 120.